You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention. You shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket this morning is Public Defender 11th Judicial Circuit of Florida versus the state of Florida.
May it please the court, Parker Thompson, representing the Public Defender for the 11th Judicial Circuit. With me at table is my partner, Julian Evans, and next to her is Mr. Carlos Martinez, the Public Defender, who I am pleased to note has just been advised he has no opposition and will be the Public Defender for at least another 4 years. Public Defender for the 11th Judicial Circuit brought the first of these actions because he determined that it could not otherwise, that is, the office could not otherwise represent its existing clients if it accepted any new non-capital felonies, so it moved for approval of its decision.
Now, let me understand this. The original request was to get off of everything except capital cases and misdemeanors?
That is correct, non-capital cases. And
what percentage of the caseload would that have been?
My recollection, Your Honor, is it would have been about 60% of the caseload, but it wasn't asking for release from any existing representation. It was not asking for withdrawal from a single case. It was asking that because of the existence of the load it was then carrying, that it be permitted to not take additional cases, non-capital cases, for a period of time. Judge Blake, the administrative...
What was that request? What period of time was the public defender asking?
It didn't ask for a specific period because it knew it had to present it to a court. And it did present it to the court by the motion. The motion went to Judge Blake, who was the administrative judge of the criminal division of the 11th Judicial Circuit, and who was a former chairman of the Circuit Judges Conference of the state, a respected judge, and he heard the case and granted the motion with certain restrictions. First, it was limited to so-called C felonies.
Third-degree felony. Is that third-degree felony?
Essentially third-degree felonies. There's a little... He made it clear that he was intending to do third-degree felonies, but it was referred to as C, A, B, and C.
And I thought those were the ones that were 60% of the public defender's caseload.
That is correct, and I may not be exactly correct on the initial request, but it was in that range. As I said, he limited it, however, in addition by two requirements. It would only last for 60 days, when it had to come to him for full review of what the present conditions were. And secondly, he required weekly reports from the Public Defender's Office of the individual caseload that I'm advised by the Public Defender that I was correct, that the non-capital were 60%.
Let me ask you, at the heart of the matter is underfunding by the legislature, correct? That's the gist of it.
Well, that certainly is a factor. If there were more funds, you could hire more people, without question. It was, in fact, there had been, as Judge Blake correctly observed, a 12.9% reduction in budgets. But there's another factor, not just underfunding. The caseload had gone up. As you know, the public defender is not in control of its own caseload. Its caseload is determined by the prosecutor. There is some irony.
Well, let's talk about the state attorneys for a minute. What if the state attorneys had been funded of a really low amount, just $100 per state attorney's office? What's the remedy there? Is there a remedy?
In the first place, I would say that there would be automatic, under the way the legislature funds the public defender's office, that the public defender would get $50, because the public defender is the recipient of essentially 50% of what the state's attorneys get.
So is there a constitutional problem with that? And if there is, what's the remedy?
I think that there is a constitutional problem without doubt. I think there is a constitutional problem both under the state and the federal constitutions. And what
is the remedy with that problem?
Well, the remedy would be for this court to make a decision of what had to be done.
How do you get to that decision? What's the appropriate procedural vehicle in order to address that problem?
I think the court would address it as it has before, under its inherent authority to protect the judicial system. And when you get to $100 for the state's attorney and $50 for the public defender, you have gutted the state's criminal justice system.
Well, we can't just all of a sudden make a decision out of thin air. How do we get there?
You get there, my assumption, it first goes not to this court, but to a trial court. And the reason for that is that we do have faith in trial judges to hear the facts and reach conclusions, as the trial court did here, and determine what...
Let me ask you about this first case you're talking about. We got two different cases, but the case that came up first. Was there an adversarial evidentiary hearing?
Yes, sir.
Okay, who was on the other side?
On the other side... On the other side was the state's attorney, that it was permitted the full scope of a party, but technically was allowed to appear as an amicus, but it was allowed to cross-examine witnesses, file briefs, and filed briefs on every
Were they allowed to present evidence?
They were allowed to present evidence and presented one witness, one factual witness. They were allowed essentially to do anything a party did.
But they were not a party.
Yes, they asked to be a party, and Judge Blake determined, based upon authority from this court, that they should not be a party. After all, you see, the statute provides that the motion will be submitted to the court, It doesn't say anybody will be a party. I mean, that happens often, that matters are submitted to the court. In this particular case, the state asked to be appearing through the state's attorney, and Judge Blake essentially permitted them full appearance.
Just so I'm clear, what exactly is it that you're asking us to do? What ruling do you want from this court?
We believe that this court should reverse the 3rd District Court of Appeal for a variety of reasons and remand it to the trial court. The trial court would then presumptively hold the hearing it would have held in 60 days after it issued its order as to whether the conditions that existed then still remain.
Okay.
And to grant an appropriate remedy.
All right, so say the trial court allows the public defender to withdraw from all these third-degree felonies.
Well, I repeat.
Who's going to represent these folks?
First, Your Honor, I repeat, the public defender did not ask to withdraw from a single case.
No, you asked not to be appointed to
that is
new
not
cases,
to be appointed in future cases. And Judge Blake, the trial judge, ruled based on a factual analysis that the individuals that were presently being represented were being represented minimally effectively, the bottom. And he simply said the obvious. If you take more cases during this limited period of time, you cannot represent both the ones you're already representing and the new ones effectively.
But
you cannot.
Who would represent the new folks? That's what I'm concerned.
Well,
I understand the budget
legislature has told you who would represent the new folks. If the public defender, by reason of conflict, cannot represent anybody, that matter or that case passes to the regional council. If the regional council cannot represent any individual, the legislature has told the world that the private attorneys on the list will then represent those people. And that's what the legislature has prescribed. First the public defender, then the regional council, then private counsel on the list.
Was there any evidence about how many of these third-degree felonies are filed in a month's period, for example?
Well, Judge Blake took the entire caseload and broke it down as to which were filed and where they went. Did they go to a private attorney? Did they, were they, what's the phrase, PTI'd? He broke it down into a separate exhibit, which is an exhibit in this case. The net of it was, as I recall, 11,000. And he applied...
11,000 what?
11,000 non-capital C felonies.
Per month, per year? I mean, I'm trying to get some idea. If, for example, we said, yes, the third district should be reversed, we'll go back to the trial court. And if the trial court is saying, you can get off, you will not be appointed for a 60-day period.
Essentially, when I said that number of cases, I was talking about the then inventory of cases over the year. Now, if in fact third-degree felonies were not taken for 60 days, I read that as approximately 2,000 cases.
Somehow the number, the record says that the caseload average at the 11th Circuit in Miami was 436 cases per lawyer. Is that correct?
Yes.
Is that an accurate assessment?
That is correct.
So 436 cases per attorney, third-degree felonies and below.
Yes. As we all know, the criminal system is cyclical. So we look at a point of time. This court has reported that the number of arrests has gone down, so it may have gone down some. But at that particular point of time, it was in the range of 436. You said 450. Yes.
There are two cases that are consolidated, and we've been talking about the first case. But after the third district reversed the first case, the second case was brought, the state of Florida versus Antoine Bowens. And in that case, that particular public defender, it was...
Jay Colston.
He had
You'd had in the previous
600
year
cases?
971 cases, and in the current year, it appeared to be in that kind of range, 700 cases maybe.
Well, do you...
Is that felony? I'm sorry. Was that felony cases
Yes,
or?
yes. He was a C attorney. That's a C case. He was handling C felonies, which is, Your Honor has said, are essentially third-degree felonies. In the previous year, 971. In this year, about, as I recollect, it was about 110, and you put a multiple of 5 or 6 on that. So as Judge Thornton said, it was in the range of 600-700 in this year, almost 1,000 in the previous year.
So don't we really separate out, I mean, although the cases are now consolidated, Judge Thornton in his order said that after he had the evidentiary hearing in that case, that he found that if an assistant public defender requests permission to withdraw from representation of a client because of excessive caseload, there must be a showing of substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibility to another client. We've been talking about what the remedy is, but I want to understand what you're saying the law in this area should be. That is, that it's not simply excessive caseload, but there has to be some relationship to the ability of that lawyer to competently and effectively represent their clients. So what would you say to be the rule of law coming out of the Bowens case, and is it different from the rule of law that would be coming out of the first consolidated case that the public defender brought to try to globally get off of all of the non-capital felonies? Do you understand my question?
I understand your question, Your Honor. But I don't think it would be a different...
So what is the rule of law then?
The rule of law was established by this court in Rule 4-1.7, where it said that except as provided in subdivision B, a lawyer shall not represent a client. This is Judge Thornton's words. There is a substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibility to another client.
All right, so that's the part I read from. So therefore, you would, because in reading our prior cases, and in particular Justice Harding's concurrence, he did not envision that there would be, when this kind of catastrophic situation occurred, that there would have to be a full-blown evidentiary hearing. He wanted to rely on the good faith of the public defender. At that point, as you know, there was...
Your Honor, that was a concurrence.
That was a concurrence. But you would agree, then, that the obligation of the public defender is first to make his or her own good faith assessment of the caseload, and to see that as the catastrophe is about to occur, to look at all his or her personnel, make the appropriate adjustments, obviously not getting off of the most serious cases, the capital cases, and then it would have to go to a full-blown hearing before a trial judge. Is that
Your Honor,
so you would agree? I mean, that's the procedure.
Absolutely. I would agree. The public defender is a
shouldn't
constitutional officer and must make that determination, and then he is required by statute and by the precedent in this court to submit it to a court for review.
But shouldn't the state then, in that situation, I know you said they were amicus, but shouldn't they be an actual party in that? I mean, I think our case law has held that they should be a party.
Had the state appeared in the normal fashion through the Attorney General or the Judicial Administrative Commission, the public defender would have had no problem. It is the prosecutors, however, that set the caseload of the public defender. And in this case, they first set the caseload, and then they wanted to object and argue against and contest the public defender's decision to not represent certain people.
If you excuse me, what do you mean by that term, that they set the caseload?
They set the caseload by processing arrests into cases. And they select the charges, and the public defender defends them.
But that's not necessarily translate to the public, setting the public defender's caseload to me, because you have to take into consideration that they're private lawyers who come in and handle some of these cases. And so I'm not sure that I totally agree with you that they actually set the caseload. And I thought we said in the Johnson case that the state was a party to these kinds of proceedings.
Well, there's no question that the state is a party. The state is a party to every criminal case. The regional counsel filed an amicus brief in this before this court, which directs itself to the standing issues and points out that just because it's a criminal case, the prosecutor does not appear on every motion that deals with procedural matters between the court and the public defender. And there is nothing to indicate by the process that the statute sets that the court must review it, or by anything that this court has said that it is anything more than between the public defender and the court. But in any case, whether they were classified as a party or not, they were a party. There can be no doubt. If anybody looks at the record, they had full rights as a party and exercised them.
In terms of what they, and I see you're in your rebuttal, but I just wanted to ask, it was in the third district opinion. In terms of the scope of the inquiry, one of the opinions in the third district said that there was a decision made that the public defender would stay on misdemeanors and not be on third-degree felonies. Is that, if the decision was, is there unfettered discretion for the public defender to decide, not to hire, to give further, higher salaries, to decide we're going to be on these cases and not on, you would think that you'd start with, well, we'll get off the misdemeanors because of the triaging. So what is the scope of the examination by the state, as well as the court's inquiry as to the reasonableness of the decisions that are made since on the caseload?
That was addressed at the record, in the record, and it was addressed in Judge Blake's order. The state proposed that should go to misdemeanors first. It proposed it through examination of the then public defender, Bennett Brummer. And Mr. Brummer responded that there were three reasons actually, that didn't go that way. First, it wouldn't have solved the problem. There weren't enough. It wouldn't have sufficiently reduced the forward-looking docket of the public defender. Secondly, he needed the misdemeanor court as a training ground for new counsel so that they could work up to felonies. If you abolish county court, there would be no such training ground. So it wouldn't take care of the problem. And he needed those people, those junior lawyers there as a training ground.
So they were having such high turnover.
Right. And then Judge Blake looked at that and said, that's his testimony. It's unrebutted, and there is no evidence whatsoever that cases in other circuits, the conditions in other circuits are the same as they are in the 11th Judicial Circuit. So I accept Mr. Brummer's explanation, and I accept it as being accurate. That's what trial judges are for.
Mr. Thompson, you have now exhausted all your time. I will nonetheless give you 2 minutes for rebuttal.
Thank you, Your Honor.
May it please the court. I'm Louis Hubiner on behalf of the state in this case. With me at counsel table are Penny Brill, Assistant State Attorney from the 11th Circuit, Buddy Jacobs, General Counsel for the Florida Prosecutors Association, and Bill Evans, who is a State Attorney in the 1st Judicial Circuit and President of the Association. Ms. Brill and Mr. Jacobs were present during the trial proceedings in the first case, the public defender case.
Mr. Hubner, I wanted to ask Mr. Thompson, but there's just not enough airtime to ask full questions. But it seems to me our initial discussion here it was not directed to what really is the substance of what's before us, and that is the right to counsel. and what does that mean, and how is that enforced? Right. And it seems as though you all have a fundamental disagreement. One side says that it's a substantial risk, and I believe your position is that you must show actual prejudice in each individual case. Exactly. So I'd like for you to please address those, and the question of effectiveness and efficiency if you have to do it in each individual case. Do you have, and every time this comes up, if you've got a serious problem, do you have to spend a week litigating on who takes the case as opposed to providing representation, which is, I thought, is what this whole system was about?
I think you've touched on just about every issue in the brief, so I'll...
Well, I think it's an improper forum to engage in a political debate.
I agree.
I think we need to get to the constitutional basis, and how is that constitutional issue addressed, not the other fringe issues.
Right, okay. Well, first of all, I think the statute, 255303, 1A and 1D are what control in this case. In terms of what must be shown in order to withdraw. And what we're talking about, I think, because of the legislature's constitutional authority to prescribe the duties of the public defender, is what must be shown for a public defender to withdraw from the case. And the legislature has said that excess caseload and underfunding alone are not sufficient.
But it is the product of that is what we're really looking at,
right.
Because it's not a legislative mandate, it's a constitutional mandate to provide counsel.
Right.
And so we don't send third graders in to defend, and we don't pay 15 cents to any office and expect them to satisfy the constitutional obligation. So that's where I want to go.
Well, the constitutional obligation, of course, is the Sixth Amendment right to effective counsel.
And that's not a legislative mandate.
No,
it's a constitutional
mandate. So the question is, how do we address and provide for that, not only in routine years, but in bad years when we're dealing with money problems on a statewide basis. And that is part of the problem that existed 3 or 4 years ago when these cases came up, and I think the situation has improved markedly since then. But the standard that the third district came out with is what we support, and that is what must be shown in addition is some kind of prejudice. You can't go in...
So then you have to do it on each individual case.
Normally, yes.
So then can you help me understand how it would be effective or the efficient use of anything to litigate in every case? And there's, 47,000 in Dade County? You'd spend your entire time talking about whether you're going to represent them or not, rather than trying to get to what this whole system is about.
Well, I think in both cases, the evidence did not show that the public defender was not ineffectively representing anyone.
You see, I guess it goes back to this. I agree that there has to be something more, and I think we all agree with it, than excessive caseload. But what is wrong with the standard that's set forth in Judge Thornton's order that there has to be a showing of a substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities? And that was, I mean, if this had been let to go, Judge Blake would have had 60 days, would have seen how it went. He was administrative judge over all of those criminal cases. And would have been able to then readjust it. They weren't asking for some irresponsible thing. I think they were doing, and this is what's so hard, the responsible thing. I can't believe that there was a lawyer that had a caseload during a year of 600 cases. Well, we're sitting here and we expect public defenders to advise on the plea, on the consequences of plea. We deportation now, what the sentence options are, the object during a trial and object with a specific objection. We're talking about a lawyer in the Bowens case that had a caseload of over 600.
Well, there was a reason for that. And the reason was another attorney in the section of the court, the felony section of the court in which he worked, resigned and was not replaced, and he had to pick up that.
Well, so he came in and he was given with a very narrow order to be able to withdraw in those cases for a time certain. And again, going back to the question of
Mr. Kolsky only was trying to withdraw from one case.
But those cases, but that case was quashed. That order was reversed as well. That's why I asked.
Well, because what the court, when it got to the DCA, what the court found was that all that Mr. Kolsky had testified to was that he was going to have to get a continuance to work on the Bowen case and waive the speedy trial rule. That's not prejudice to any Sixth Amendment right. And that was really the limit of his testimony. Now, to get back to Justice Lewis's question about what can you do when we have large numbers and the contention that effective assistance might not be given, I would not say that in every circumstance that you would have to withdraw on an individual basis. I would say that if there were some systemic problem that the public defender could establish that showed, I will never get to these cases, I can't do them, even if you give me continuances, it's just never going to happen, then that is a systemic problem, and I think that could be raised in the appropriate way. But I also think that a claim like that means that the court has to take a lot closer look at the office management than either of the trial judges in either of these cases was willing to do. And
how would that be done? That sounds to me like you're saying that the trial judge has to sort of micromanage and make decisions about how the public defender should be using resources.
Well, this court authorized a procedure of exactly like that over a period of years in all the cases that were coming up from the 10th Circuit public defender. And you authorized the appointment of a commissioner to look into, among other things, how the public defender's office was using its resources. Now, I would say in this case, hear me out, there was evidence that Mr. Brummer had not used 16 authorized, funded attorney positions in the 3 years before he filed this action. And I think when something like that comes up, a court...
What was the evidence of why that was done?
Well, I think the evidence was pretty skimpy. What Mr. Brummer said was, well, I really can't hire the attorneys I want at the low end of the salary, so I use that money to raise other salaries in the office.
So that you'd have some more you see, the problem, I think, is, because you're suggesting at least that there's an evidentiary basis, and I think everybody seems to agree with that. On the 10th Circuit public defender, it was really the second district that decided to have the commissioner, I thought, not us. We said that was appropriate. We authorized it because that was what was requested. But down in terms of this issue of whether the public defender made a good faith decision to decide how the scarce resources were going to be used, it seems that there we really are getting into an area that is not appropriate for the judicial system to get into. And I think that the idea that over the public defender who is in the 11th Circuit who has to run for election makes a decision during a crisis time that we need relief rather than wait till after the fact seems like a responsible decision. My concern is that if the court were to get into the kinds of inquiry that you're suggesting, well, Mr. Brummer, why didn't you hire, I could give you 10 lawyers at a law school that would love this job. Why don't you hire them and then they can go into the felony division? Is that really what we want our courts to be doing?
I think in the appropriate case, yes, because he has to be accountable to someone for the use of his resources. Every other official
but are you I guess
has to account for the appropriate use of their resources.
He's elected, right?
He is elected.
Isn't he accountable to the public?
He's accountable to the public, but not, I mean, the public doesn't know about how resources are being used, and when he wants to withdraw from cases...
we should also micromanage the state attorney's office also?
The state attorney's office is not asking for any relief. I'm not suggesting that, but here, when somebody is coming in and say, I want out of... I think the result would have been the transfer of 11,000 or more cases to the regional counsel's office. That maybe they are overworked. Maybe they are providing effective assistance of counsel. But when they want relief like that, I think it's appropriate for a court to assure itself that this is not something that is attributable to bad management.
Did you say that they were asked, but didn't Judge Blake's order, it wasn't going to be 11,000 cases, it was a 60-day period that he was relieving them from, and then was going to be having them report on a weekly basis, and then at 60 days review it again, isn't it? So that wouldn't have been a transfer of 11,000 of their cases, would it?
That's the number that comes to mind.
I didn't. I mean, it would seem to me it would be hard for me to believe in 60 days 11,000 new felony cases.
But that I think maybe that was the number that equated to the 60% of the workload
yearly. But that wasn't. And I think though it didn't. If Judge Blake had said you're off for the next year, or there was some issue there, but can you really? Let me just as far as the remedy. That was the initial remedy there. You're suggesting that there should have been more testimony, because I think in the bottom line you're agreeing that there is a responsibility for the court to be looking at this from the point of view of the constitutional rights of the indigent.
I don't agree with the basis of what Judge Blake did at all, because
but you agree,
they proceeded on an average caseload number, which is contrary to the statute, okay, first of all. Secondly, if you look at the evidence, that was an office-wide caseload number.
Are you saying if the judge cannot look at the overload, case overload, I mean, of this proportion, cannot consider it at all because of the statute determining whether or not there's an effective assistance for counsel?
Well, the statute says workload to begin with. I mean, caseload is not necessarily a number that tells you much of anything. And what the state attorney's evidence showed...
Now, don't we have standards from the Public Defender Association, the ABA, et cetera, and it showed that their caseload was twice the highest recommended standard throughout the nation?
The average annual caseload for the attorneys in the felony division, by our calculation, and I don't think it's seriously disputed, was 240, not 436. Now, that's on the high end. But again, what the legislature says in this area, because it has the constitutional authority to decide the duties, is controlling. And it says excess workload alone is not enough. There must be a showing of some prejudice.
But again, there was something here more than just workload. Both cases addressed the impact of that workload. That's what you're talking about, right? What is the effect of the excessive workload? That's where you're going. Was that addressed here? I thought that it was.
Pardon?
It's not just the issue of numbers with regard to workload. This case, there was evidence with regard to the impact of that workload on the handling of cases. That's what we're looking to, isn't it?
There was very general testimony.
Well, then again, it comes back to stand. I understand you all disagree on that, so it's one actual prejudice or a substantial risk. But it was taken that further step. I don't see how you can argue that this case, the courts below did not look at the impact on the individual.
Well, there was of course, no individual that was being focused on in the public defender case.
The individual, hypothetically,
right.
The substantial risk to those people who had no attorney, who were entitled under the Constitution to representation, how it would impact them.
Well, but the particulars were very general, and they were along the order of we're rendering less effective assistance. We're not doing everything we can.
Well, I understand that's your dispute then as to specific prejudice versus a different standard. But as I understand, this case did not just stop at pure numbers. There was an attempt to address the impact of that on the representation.
I would say in the public defender case that was absolutely minimal. The case was based on
it may be minimal, but it was
caseload
addressed.
numbers
I understand.
alone.
I understand.
That was their theory. Too many. The caseload number is too high. End of story. It exceeds all the recommended numbers.
I guess if we had a situation where the third district reversed because there wasn't competent substantial evidence to support something, then we'd be in a different situation. But I think here what our responsibility is to see whether the legislative directive that you cannot withdraw solely because of excessive caseload then requires something other, and we all agree there has to be something other. So aren't we really here to decide what the something other would be? And then, since this is relatively, we're now 4 years later, it obviously has to go back for a whole new evidentiary hearing, and maybe the public defender isn't going to be requesting relief in 2012. So isn't that, I mean, that's the guidance we need to give. Either the third district is right, or the trial court used the correct standard, and then the question of whether there should be more evidence, it seems like between the case of the public defender and then the Bowens case, they did put on more evidence, and so wouldn't that be the way to handle it?
It would, and I think the standard going back is not the bar rule. It's the standard which I think is very general. It's a disciplinary rule. It does not distinguish between public and private lawyers. I think what the legislature, what the third district said,
it doesn't distinguish between public, but when we look at effective assistance of counsel,
right,
we don't have a different standard for indigent defendants than we do for the rich, do we?
No, you don't.
And I'm thinking in the days that there were only private lawyers that would take over when the public defender conflicted out. And I'd like to think of a situation where a judge would continue to assign a lawyer to cases when their caseload had, whether it's, we'll just have to take the, it was 400 cases or 200 cases, and active cases. I don't think that would you agree that in the private sector, that if we started to see and we were assigning cases, that lawyer's caseload was at that level, that we would, a judge would continue to assign cases to that lawyer?
Well, private lawyers generally can avoid appointment to begin with, just for financial reasons. But
if I'm a lawyer that lives off of these cases, I want more of them.
Once they get a case, if they want to withdraw, then they should be required to show the same imminent and actual prejudice to a constitutional right.
I think you're missing my point. My point is that when we're looking at what is reasonable, I thought you were suggesting that the bar rule was somehow different for public defenders as it was for private lawyers, and you agree that there's not a different standard.
You have not interpreted the bar rule in any case that I'm aware of in circumstances like this. I think the language in the bar rule that about substantial risk that representation will be materially limited is a much looser standard than the third district's actual and imminent prejudice.
So let me ask you this. Did I understand you correctly that you believe that in some circumstances we can look at the public defender, whether you're talking about withdrawal or whether you're talking about not being appointed in the aggregate, at more than one case at a time? Now you can do that. Is that your position? You can do that.
I think there may be rare instances when there is a systemic problem, and there are cases that the public defender can say in good faith, we just can't do.
Then what is the standard? I mean, if you can do this on an other than a case-by-case basis, then it seems to me that it would be virtually impossible to have a standard that says actual prejudice.
Well, I mean, obviously, if there is actual prejudice, you have a Sixth Amendment problem. If the state attorney, the public defender can say, we just can't do these cases, then obviously that's ineffective assistance. That's no assistance.
So you think the saying of "I can't do these cases" is actual prejudice?
Yes.
Okay.
Yeah. I mean, if they can show that, but again, I think there may be appropriate circumstances in which the court would be justified in looking at office management. We would ask you to affirm the decision, the two decisions of the Third District. Thank you.
May it please the court, these are lengthy records. They were chilling records as to what the individual lawyers could and couldn't do. Kolsky testified that in something like 40-50% of people, he had no opportunity time-wise to brief a person before plea. In light of Padilla, Lafler, Fry, what does that say? It says that the public defender has to deal with reality. And reality was testified to. And although the Third District ignored the factual findings, and the state in its brief ignored the factual findings, Judge Blake said that he found that the evidence shows that the number of active cases is so high that the assistant public offenders are, at best, providing minimal competent representation to the accused of its current. And the evidence clearly establishes that PD 11 is in need of relief sufficient to ensure that the assistant public defenders are able to comply with the Florida rules of professional conduct and carry out their constitutional duties. And in the Bowens case, Judge Thornton made a finding as to his management of the office and found it was highly satisfactory in these days of very difficult times. Those are the findings of trial judges, good trial judges. They weren't even addressed by the Third District. The Third District considers them irrelevant, and Mr. Hubiner today considers them irrelevant. I do not believe that this court wishes its lawyers, members of the Florida bar, whether public or private, to not do what they are supposed to do. And who told them what they're supposed to do? This court. And this court said, when you can't represent a person, get out of it. And if you have not yet accepted representation, decline. That's what this court says. And it said if you've already accepted the representation, then withdraw. Well, in this case, they did exactly what this court said. PD 11 did exactly what this court said. It asked to decline further representation so it could give effective representation. And the judge said, right, but I'm going to monitor this. I'm going to sit on top of it.
Mr. Thompson, is the monitoring legally sufficient so that public defenders throughout the state could not abdicate their responsibilities and usurp the power of another branch of government by simply willy-nilly doing what they want to do?
Your Honor, I believe so.
Because that's the argument, is that this is
not.
Well,
Judge Thornton said, I do not believe, what Judge Blake said, I find that the public defender sincerely believes what it is saying. Judge Thornton said that Kolsky did not withdraw for any reason other than the fact he was overloaded, couldn't do his job. I mean, that's what trial judges are for. And I believe that trial judges can monitor the 11th or the 1st or any, if there is an argument that in fact they aren't doing their duty. And of course, as has been pointed out, if they aren't doing their duty, it'd be a very, very good campaign platform against them at the end of their term. Thank you, Your Honor.
We thank you both for your argument. We now move to the second case on our docket, which is in re amendments to the Florida Rules of Criminal Procedure.
What is this? Is this a social gathering? No. They must think they're in the court.
Please proceed.
Good morning, Justices. I'm Donald Scaglione, current chair of the Criminal Rules Committee. We're here on our 3-year cycle report of submissions that have been made through 2008-2011. I've reviewed the submissions that are currently before the court at this time, and most of them are stylistic or clerical scriveners. I believe there may be only 2 issues that are adversarial. One internal with our own Criminal Rules Committee, where we have a minority report presented by Abe Laser, one of the prior chairpersons of the Criminal Rules Committee, as to discovery. The other one as to withdrawal plea was 3.170L, which is court heard an argument as to the Criminal Court Steering Committee. I believe it was 2011-1699. I'll be happy to answer any questions as to the other issues. You will find that we have, as a committee, made submissions, like for the appointment of indigents at the request of Judge Barber out of Hillsborough County. At the time, he was a county judge. He's now ascended to the circuit bench. And after reviewing the comments, we withdrew that recommendation. You also find that as to the notice of appear, that's basically a statutory inclusion of a handicap issue. I can direct you to the attachment of B12 that is there. As to Rule 3.140, it coincides with Rule of Judicial Administration 2.55 as to language and including on the informations and indictments. I'd like to pass over 3.170 because I believe that's the one that's got the most controversy. I know that's what my counsel here is here to speak about. I know I was here present when the Criminal Court Steering Committee, and I was present for any questions at that time, and that was extensively litigated as well as questioned by this honorable court as to the withdrawal plea in 2011-1679. If you look at 3.191, I direct your attention to attachment B36. That basically is a scrivener's as to specifically pointing out in the rule as to when the notice of expiration needed to be on there. 3.220 is the other potential controversial issue as about the issuance of subpoenas ducus tecums. Abe Laser, the former past chair, brought out that he would like some additional language beyond the language that was submitted by the Criminal Rules Committee, that this starts reciprocal discovery, and that is in his addendum of G1. If you look at 3.410, that is additional information before coming before the court. From being before this court, talking about e-file, e-portal, and electronic courts has come in, this is only a stepping stone. I noticed that many of these rules that are coming through the 3-year cycle report at this point in time may have to be modified and changed based upon the court's rulings on the e-file, e-portal decisions that have to come through. The Criminal Rules Committee did, in fact, change a couple of the sentences there. I think as a practitioner, as a trial judge, we don't do anything outside the presence of the parties. This just codifies it to make sure everyone knows if you're going to bring the jury back in, all the parties need to be there. They need to be present for the readback. If there's something to be in writing, there has to be something placed in the file, and all the parties have to be noticed as well as have the opportunity to appear and object to it. 3.590, I direct your attention to B69. It talks about just the issue of timing. 3.691, direct your attention to B71, where it talks about specifically it needs to be addressed to the appellate rules, not really to the criminal rules. 3.70, there is no attachments to that because after reading the comments of the Public Defender Association, the Criminal Rules Committee made a determination that it was best that we not make any changes, and we withdrew the amendments that we had initially proposed. The 3.800, I direct your attention to B73. It talks about the inclusion of the sexual offender, sexual predator designation as to being able to come under the 3.800 series to attack that. So that's basically codified. That's one I believe that may have to impact with the Criminal Court Steering Committee's 11/16/99.
But just on that one, the 3.8, I mean, if in the meantime there would be no harm in amending it, even if we end up changing all of the post-conviction rules, because that makes clear that if there is an erroneous sexual predator designation, that can be, relief can be sought under 3.800A. Is that correct?
That's correct. I would agree with the Justice that that would be the most prudent thing to do at this time. But knowing with everything that we know is coming through the pipeline,
we just don't know when the pipeline will be completed. So that one seemed like something that we could do even if we end up changing the whole way the post-conviction process works.
The 3851 was submitted by Bob Strain, who was the previous chair of the Criminal Rules Committee. It basically talks about maintaining the confidentiality of psychiatric reports and mental health reports.
But we've already rejected, I mean, that was a subject of the implementation on privacy, and I think we had already haven't we already rejected that, the issue of just blanket sealing of mental health reports?
You did, I believe.
All right. Well, we know. I think so. That was something that the committee, maybe when they voted on it, maybe we hadn't come out with.
A lot of these issues were prior to that, and Mr. Strain, being a CCR, dealing with the death penalty and the post-conviction issues, thought it was important. We all know how the press likes to saturate information. If a case gets overturned, if they're part of the public venue, I believe you'd be afraid that some of this information would saturate the public venue prior to a possible retrial. And I believe that's everything other than the 3.170C, I talk about the withdrawal of plea. As I sat through the arguments for the Criminal Court Steering Committee and heard the rebuttal arguments from the public defenders, I seemed to see the justice kind of locked in on that. One thing that was brought up to me by Judge Emus, who was making the argument, Judge Harkins that was making the argument, that I don't believe they had the opportunity to say, is it does impact the trial courts. We're seeing it as trial judges come back numerous times. It doesn't affect the ability to withdraw a plea prior to sentencing. There's a prior section of that. But when we do see them, they're actually raising issues of post-conviction ineffective assistance. So it's being dealt with in a duality that we're having to deal with it on a motion withdrawal plea, and then it's being brought back later on a post-conviction issue. So it's being addressed at two times. It is the position of the Criminal Rules Committee as well as the Criminal Court Steering Committee that by deleting this, due process and protections for the defendant would still be there by being able to be raised through the 3.850 ineffective assistance issues that are there. I'm open for any type of question.
We're talking about the rule that says you can file the motion to withdraw within 30 days of sentencing. Is that and so I guess my question is, usually the 3.850 is somewhere later down the line, and so why wouldn't you want to do it at an earlier point in time?
I believe that from the arguments that I heard on 2011-1699 and what I see as a trial court is the issues that are raised are ineffective. They're usually summarily denied because most of the time they're being filed by pro se litigants. If there is anything of factual concern that the trial courts are finding there, you end up having to appoint collateral counsel because they're usually attacking their previous counsel that's there. We're not seeing that it is assisting the system of justice going through. It's actually creating more work, and it's time, and I hate to use the word financial concerns because due process should not balance into any financial issues. the right to the independent.
So I understand what you're saying. I guess then, and we probably have to go back to that oral argument because we obviously engaged in it, is that the idea, are you saying that really those 30 days after, you're not seeing as a trial judge that any of these, like that the plea should be overturned? I mean, we've just heard all these situations where public defenders don't have the ability really to advise. We got Padilla situations that I guess I've always thought the idea that if somebody wanted to withdraw that plea within 30 days of sentencing, and really go to trial, that's the time to do it. Now, if they're attacking it's because they're only dealing with pleas. So are you not finding any of these to be ones where you would actually set aside the plea? Because that's really what we're looking at. If 100% of them are not set aside, and then they just do it again afterwards, then we are inefficient.
From speaking to Judge Emis and Judge Harkins, they're not finding many of them being overturned. I can tell you, as a trial judge, maybe 2% in my court, because they're not bringing the issues that are relevant. Usually it's a buyer's remorse. They go to the jail and they listen to the other inmates that always have more knowledge than their trained licensed attorneys and say, you should have done this, you should have done that. And we've also seen numerous times where cases have come back, and when they find out they're actually facing a lot more severe sanctions, they don't want to withdraw their plea. So that's taken a lot of time and resources.
But then at that point, why wouldn't that be, then it would have been litigated. So if they bring it again 4 years later, they're bound, they've litigated the issue. I mean, we haven't had a case on that, but to me that's the answer to that they can't just raise the issue they raised. At least now you have the lawyer there who remembers what he or she advised on, and it's done then, not 2 years after the fact. So that's just one of it's sort of, again, I realize I'm not on the ground, so I appreciate it, but wouldn't that be the solution, to say that they're barred if they've raised those issues after the fact?
Well, that's the status of the law. If they're barred, if they could have, should have, would have brought it up, the problem is they continue to bring it up. Even though we may have litigated it, it still comes back again, and in death penalty cases, they come before you numerous times on issues that were handled on direct appeal or on previous 3850s. So the fact that they say they shouldn't is not going to stop the process. It's going to continue to come back through, and I think the submission, that's why the criminal rules as well as the Criminal Court Steering Committee, is that at least this will streamline it a little bit. We will deal with it one time, because we know we're going to get it. Are we going to get it once, twice, 3 times? Any other questions? Thank you all very much.
May it please the Court, Glenn Gifford on behalf of the Florida Public Defender Association. I'm here to speak only on Rule 3.170L. And just briefly, this was argued in January in 1169. That case is still pending. Just to briefly reiterate our position, this rule effectuates the right to challenge the voluntariness of a plea and whether a sentence exceeds the plea agreement on direct appeal. That was recognized in Robinson, and it provides a means to preserve this issue in the trial court at a time when the defendant has counsel, both in the trial court up to 30 days before the notice of appeal is filed, and then on direct appeal. There's a right to direct appeal. There's a right to counsel. Robinson recognizes that these issues can be raised on direct appeal, and after the Criminal Appeals Reform Act, they have to be preserved by a motion in the trial court. So these motions will continue to be filed, whether there's a Rule 3.170L or not, according to Robinson. Second, it's very important that this opportunity exists at the time within 30 days after the plea because of the right to counsel. If you defer this to 3.850 proceedings, there is no right to counsel to help prepare the motion. Often litigants are unrepresented in a hearing on that.
Well, we understand that, but what the trial judges are saying, and appellate judges, is that all we're doing is creating another avenue for abuse of the process. Now, you know that when we created it, it was exactly for that, so that we could see that an error gets corrected at the earliest possible stage. But it's been represented that it sounds like 98% of these are not frivolous, but are just, all they're doing is just saying, well, we wish we hadn't entered that plea, and they've already entered it. So what do you, we don't have any numbers, but what is the opposite side of that?
Well, those 98% that are frivolous can be dealt with and dismissed rather summarily. This court in Shepard narrowed the grounds to when counsel has misrepresented something, misadvised the defendant, or coerced the plea. If the motion doesn't allege any of those grounds, then at that point it can be dismissed without further hearing. And then further, if those grounds are alleged, only then is conflict counsel appointed. So 98% of these cases, a good portion of that 98% is going to be dismissed without a hearing, without much trouble. That remaining 2% is very important. If the defendant gets relief and then goes to trial, the law presumes is in favor of trial on the merits. So that 2% is important. Most of the abusive practices, I think, have been curbed. I don't have the stats, but I look at Shepard, and I think Shepard was effective in curbing the abusive practices by limiting the grounds, narrowing the grounds, and then requiring appointment of counsel if specific allegations are made in the motion. Again, I would refer the court back to our comments in the previous case and to the oral argument where this was addressed in some detail. If the court has no further questions, I'll conclude.
If the court doesn't have any questions, I'll just add one additional issue. Counsel brought up about the fact about a coerced plea. We now know the Supreme Court has issued something about lawyers trying to encourage their clients to take pleas. And I think we're going to run into some definitional problems there. Just how far does defense counsel have to do to convince their client that what's in their best interest? Of course, if they recommend a plea to, say, 5 years, they get convicted and it's a first-degree felony punishable by life and they get life, does the counsel have to arm twist them to tell them to take their case? And I can see that coming before this court to give us some definitional guidance as to what's going to be the manifest injustice. Just how far is counsel going to have to push that? That may have to impact our decision-making on our motion to withdraw a plea. But outside of that, I'm available for any further comments. If not, thank you very much, and we'll await your decision.
I have just one comment. It says doesn't go, and I appreciate your service. As the senior member of the court, I just wanted to take a moment to say that this is Chief Justice Kennedy's last oral argument as Chief Justice, and we will be turning the gavel over to Justice Polston. And for the last 2 years, Chief Justice Kennedy has served not only this court but the state in a admirable way, and we on the court will miss that leadership, but we know we'll be in good hands. So I wanted to just make sure we reflected on that today, and thank you.
Congratulations, Chief.
Well, we thank you. Thank you very much. I appreciate that. That is very kind of you. We appreciate your argument here today and your contribution to our consideration of these matters. Court is now adjourned.
Stay tuned.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Headlines starts now. Hello and welcome to another edition of FSU Headlines. I'm Dennis Schnitker.
And I'm Vanessa Nguyen. It's said that music can heal the soul. At Florida State University, a longtime researcher and professor is using music to heal the youngest of souls, premature babies. The sweet sound of music can soothe the mind and body. At Florida State University, a professor has used the power of music to develop a musical device which helps premature infants grow and become healthy.
And it seems the problem is when the babies are born very early, the neurological system is too immature to support independent feeding.
As babies suck on the pacifier-activated lullaby device, or PAL,